There's some misinformation going around the internet involving whether or not Article 1 of the United States Constitution, which talks about Congress and the militia, somehow trumps the Second Amendment's right to keep and bear arms. The answer is it 100% does not even close. But let's talk about some of these myths for a few minutes, just so you have the historical and legal realities for your arsenal of arguments against the anti-gunners. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Down, our Second Amendment channel, please do so. Show your love for the four boxes of American liberty and Frederick Douglass. Okay, folks. So over the last week or two, people have been sending me videos of certain people trying to make the case that the references to militias in Article 1 of the United States Constitution somehow has significance to our right to keep and bear arms. This is obviously not true, because these arguments about the role of Article 1 were raised in multiple Supreme Court cases, including Heller, and the Supreme Court saw right through those arguments and concluded that we indeed have an individual right to keep and bear arms. To keep means to possess, and to bear means to carry outside the home, as we know from Heller and, of course, from NYSERPA versus Bruin. Now, I want to talk for just about 5 minutes here so you understand the interplay between Article 1, militias, and the Second Amendment's reference to militias. To begin with, the United States Constitution was first adopted without the Bill of Rights, but as a condition of the voting in support of the Constitution by certain states, there's an understanding that a Bill of Rights would be added to the Constitution, which of course became the first 10 amendments, the Bill of Rights. Now, Article 1 of the United States Constitution talks about the powers of Congress. If you look at the Constitution itself, Article 1 deals with the powers of Congress, Article 2 deals with the powers of the presidency, the executive branch, and Article 3 deals with the powers and authority of federal courts, specifically the Supreme Court and any inferior courts that Congress wants to create under the Supreme Court. So, with that said, if you look at Article 1 of the U.S. Constitution, it does have references to certain instances where Congress can provide for the militia. Now, anti-gunners try to say that because there is language in Article 1 dealing with congressional powers over or relating to the militia, this somehow suggests that Congress, at the end of the day, a government, gets to control the militia, arm the militia, take over the militia, and disarm the militia or whatever it wants to do. But that's not true for many reasons. First of all, from a matter of common sense, number one, if Article 1 involving congressional powers touching on the militia was all that they cared about, then why is it that several years later, when the Bill of Rights was adopted, the Second Amendment's right to keep and bear arms was adopted? In other words, if all Congress cared about, or the founders cared about, was giving governmental powers over the militia and our right to keep and bear arms, then they could have just done Article 1. There was no need for the Second Amendment. Remember, the Second Amendment came later, and because the Second Amendment came later, it's really strongly indicative and proves, not just indicative, but proves that the right to keep and bear arms shall not be infringed, and nothing about Article 1 overrides that, because the Second Amendment clarifies that and came later. There'd be no need for the Second Amendment again if all of the Second Amendment or the right of the militia or whatnot was only about congressional powers or governmental powers, but that wasn't the case. The second thing is, Akis, just think about the words here, just common sense for a moment. The Bill of Rights talks about rights. Who has rights? Individuals have rights. You and I have rights. That's why it's called the Bill of Rights, individual rights. The Second Amendment falls where? That would be in the middle, in fact, at the top of the Bill of Rights. So the Second Amendment is in a set of materials, a list of rights dealing with individual rights. The Second Amendment does not appear in, let's say, a list of governmental powers or a bill of governmental powers or anything like that. Because remember, you and I as individuals have rights, governments have powers, and governments have authority. And by the way, as a side note, government can have power to do things, but that does not necessarily mean they have the authority to do that. So for example, government might have the power to murder people, or government may have the power to do terrible things. But that doesn't mean they have the legal authority to act in that way. So when you talk about governmental powers, remember you're talking about not just the power to do something, but also whether or not they have the legal authority to act in that way. But either way, with that distinction is set aside, the key is when you're talking about the Second Amendment's right to keep and bear arms, it falls within the Bill of Individual Rights, not in some sort of list of governmental powers or governmental authority. Totally separate concepts, because one is about ensuring you and I have rights, the other is about governmental powers. And although they interplay to some degree, because if you limit the government's power to act, whether it be saying they don't have the power to do X, or you limit that power by a Bill of Rights, either way you are limiting government power. So there is some finger touching going on, but at the end of the day, the Bill of Rights, including the Second Amendment, appears in a list of individual rights and not in a list of governmental powers, which is where Article 1 falls, for example. Now, let us carry on. If you go back to the founding, remember, as part of what the Supreme Court has taught, we interpret the words and the meaning of the Constitution by going back in time and asking, what did the words mean, the text of the Constitution at the time the Constitution was adopted? And what was the understanding of the people that adopted it at the time? That's sometimes referred to as the process of originalism, where you go back to the original meaning of these documents. Because if you don't anchor yourself to the original meaning of the Constitution in 1791, then it just means that modern-day judges can make up anything they want just by redefining words as they see fit. So you don't have a constitution or law anymore. You just simply have whatever judges make up, which means you've gone from a rule of law based in the text of the Constitution to the rule of men and women who just make stuff up and we have to follow along. That is not what the rule of law is supposed to be about, at least. So that's why we go back to 1791 to try to understand the meaning of the text of the Constitution and apply it to modern life. So let us carry on. If you look at what the militia is, the well-regulated militia we're talking about, obviously well-regulated does not mean regulated like an EPA. It just means effective. That's what the Supreme Court said in Heller. And what is the militia? Well, the militia at the end of the day is all Americans. That's the reality of it. You have militias, and the idea of the right of the people to keep and bear arms shall not be infringed. The reason why that interplayed with the militia is because the militia was drawn from we the people. Because unlike in Europe, which was a top-down system where the kings, the monarchs, the governments basically told the peasants that they were in the army, they were going to protect, and they were basically just serfs and subjects. Here in the United States, it was not top-down powers. It was really bottom-up, meaning the militias had been around, by the way, long before the creation of the U.S. Constitution. They were, again, pre-existing organizations. And remember, as Heller points out about the right to keep and bear arms, and other rights, by the way, the right to keep and bear arms was considered by the Supreme Court itself in Heller as a pre-existing right. The right to bear arms was something that existed before the Second Amendment. And that, by the way, is why when sometimes you get into a technical debate about whether or not the right to carry guns permitless, should it be considered permitless carry or constitutional carry, the argument against constitutional carry is that the Constitution, the Second Amendment, does not give us the right to keep and bear arms. What it does is recognize the pre-existing right to keep and bear arms. It codifies something that already exists. And by the way, I should note, if you read Article 1 of the U.S. Constitution, which again is the list of powers the government has, specifically the Congress has, it recognizes, if you read the language carefully, it recognizes that the militia of we the people pre-exists, already existed before the Constitution. Let's look at the language of Article 1. It says to provide for calling forth the militia. You see what I just said? To provide for calling forth the militia. This presupposes the existence of the militia. Likewise, in the next clause down in Article 1, it also says Congress has the authority, quote, to provide for organizing, arming, and disciplining the militia. Now, this is getting super geeky here, but I'm going to give it to you because a lot of you like it. In these two clauses dealing with the militia, the opening three words are to provide for. To provide for. The word for is important. Why? Because one says to provide for calling forth the militia, the other is to provide for organizing, arming, and disciplining the militia. Again, the language presupposes that the militia already exists. Let's contrast it to a different part of Article 1 of the Constitution dealing with the Navy. This is what our founding fathers wrote about the Navy. Quote, to provide and maintain a Navy. You hear what I just said? Article 1 U.S. Constitution. Quote, to provide, no for. Quote, to provide and maintain a Navy, period, close quote. Do you see how in Article 1, when they talk about the federal government creating a military force, is to provide and maintain a Navy? In contrast, when it dealt with the militia, it says to provide for certain scenarios. Specifically, just to be clear, the idea was that there might be instances where the Congress or the federal government might need to involve itself with pre-existing militias, either private militias or state-based militias, to protect the country from, and it specifies when, there might have to be some coordination between militias that pre-existed at the state and local levels in the United States with the federal military efforts. Specifically, according to Article 1, not Mark Smith saying this, it's Article 1, the Constitution. Quote, to execute the laws of the Union, suppress insurrections, and repel invasions. So there are specific instances where the federal government could provide for the calling forth of the pre-existing militias. Now, mind you that none of this has anything to do with the individual right to keep and bear arms, other than we know that militias were mostly made up of individuals who brought their own weapons. Now, the best evidence of this, that the Founding Fathers understood this relationship, was in 1792. Remember, the Constitution is first created, right, 1787 or so. The Second Amendment adopted in 1791, and in 1792, less than a year after the adoption of the Second Amendment, guess what happens? Congress adopts the Militia Act of 1792. This is Congress. So you see, Congress does in fact provide for the calling forth of the militia and to provide for the organizing, arming, and disciplining, right? And how do they provide for? I mean, what laws did they pass at the time of our founding? Well, in 1792, we know. In 1792, Congress passed a law called the Militia Act of 1792, which did these things. And what did the Militia Act of 1792 teach us? Or what did it provide for and require of Americans vis-a-vis the right to keep and bear arms? Well, it's quite simple. The Militia Act of 1792 required that all able-bodied American males who are white between the ages of 18 is very important, right, in the 18 to 21-year-old fight today about who gets guns. The 18 to 45 years of age, they were required to bring with them to militia duty their firearms and ammunition and weapons that they owned already in their homes. In other words, Congress, when talking about the militia, did not say we're going to, like with respect to the Navy, maintain a Navy and buy guns and give people guns. No, absolutely the opposite. In the Militia Act of 1792, Congress said that to the extent people have to show up for militia duty under federal law, they have to bring their own firearms and ammunition and the like. Why is that? Because everyone in the United States had guns and ammunition because it was their right. And everyone had them. So there was no debate about giving them. So you see how this all works? So when people say that Article 1 of the U.S. Constitution gives control over our right to keep and bear arms, and the Second Amendment right to keep and bear arms is somehow derivative of some governmental power, it's absurd. It simply is not historically true or even textually true if you just compare Congress's ability to, quote, provide and maintain a Navy versus to provide for certain activities with local and private militias at the time of our founding. And of course, Congress made it crystal clear in the Militia Act of 1792 that if they need the militias to come forth, that Americans are to come forth with their own firearms, which of course they owned. And the reason why they owned them is, among other reasons, in addition to the fact they wanted them and needed them, they also had the right to have them, as memorialized and codified by the right to keep and bear arms in the Second Amendment. Okay, folks, I hope this was not too geeky for you, but I wanted to let you know that any suggestion that Article 1 of the U.S. Constitution dealing with congressional power somehow trumps our right to keep and bear arms, it's simply absurd for a whole bunch of reasons, not least of which is the Second Amendment came after the creation of Article 1 of the U.S. Constitution. And the language in Article 1 about the militias is distinctly dissimilar from the language talking about the creation of, for example, the Navy. Okay, folks, hope you learned a little bit something here today. If you haven't subscribed, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.